Hey everyone. Today I'm going to discuss how forensic experts can prepare for and provide effective testimony in court. Being a good forensics scientist and being a good expert witness are related, but they are not necessarily the same thing. An expert can know the science extremely well and still have difficulty communicating that information to a judge or a jury. As our textbook explains, successful expert testimony requires more than simply knowing the results of the examination. It requires that the expert has to understand their material, communicate it clearly, remain objective, and be prepared for both direct and cross-examination. In this training, I'll discuss the phases of testimony, preparation for trial, objections, compound and leading questions, direct examination, and the goals of cross-examination, and the ways an expert can reduce their vulnerability on the witness stand. The three phases of testimony. For an expert witness, testimony can generally be divided into three major phases: qualification, direct examination, and cross-examination. The first phase establishes whether the witness is qualified to testify as an expert. The attorney may ask about the expert's education, training, experience, employment, certifications, publications, professional organizations, and previous experience related to the subject of the testimony. The important thing for the expert to remember is that the qualifications should speak for themselves. There's no reason to exaggerate credentials or try to impress the jury. The purpose is to simply establish why should this person be allowed to provide an expert opinion on this subject. Once the court accepts the witness as an expert, testimony could move into the substance of the case. Direct examination is the second phase. This is generally conducted by the attorney who called the expert witness. During direct examination, the expert may explain what evidence was received, what examinations or testing were performed, the methods that were used, the results that were obtained, and what conclusions can be reasonably drawn from those results. This is also where an expert may need to translate complicated scientific information into a language that a jury can actually understand. The goal is not to show the jury how intelligent the expert is. The goal is to help them understand the evidence. The third phase is cross-examination. Here, the opposing counsel has an opportunity to ask questions to the expert's testimony, methods and conclusions, qualifications, assumptions, or limitations. This phase can feel much more confrontational than direct examination. However, the expert needs to remember that cross-examination is part of the legal process, and the attorney is doing their job by testing the testimony. The expert's job remains exactly the same: provide accurate, objective, scientific information. Preparation for trial can look somewhat different depending on whether the expert has the opportunity to communicate with the attorney before trial or not. When you can meet with the attorney, ideally, the forensic expert will communicate with the attorney beforehand. This gives the expert an opportunity to understand what areas of their work are likely to be addressed and to explain scientific concepts to the attorney that they may not understand. The expert should review their laboratory notes, their report, photographs, testing procedures, results, and anything else connected to their conclusions. However, preparation should not become memorization. One of the ideas from our text that really stands out to me is the importance of knowing your material well enough that you can explain your findings simply. If an expert memorizes the answers to specific questions, a small change in wording can throw them off. Understanding the material allows the expert to answer the question, regardless of how it is phrased. Meeting with an attorney also does not mean allowing the attorney to tell the expert what their opinion should be. The expert is not a part of the prosecution team or the defense team. The expert's responsibility is to the evidence and the science only. If there is little or no communication with the attorney, preparation becomes a little more important. The expert may not know exactly what questions will be asked, so instead of preparing for scientific questions, they need to prepare around the entire case. Review the report from beginning to end, know the methods, know the results, know the conclusions, and just as importantly, know the limitations. I would also think about what questions I would ask if I were the opposing attorney. Where could someone challenge my analysis? Was there an alternative explanation? What limitations exist? Is there anything in my report that could easily be misunderstood? Preparing this way makes it much harder for an unexpected question to completely derail the testimony. During testimony, attorneys may object to questions asked by the opposing counsel. An objection is essentially an attorney asking the judge to determine whether a question or answer is legally appropriate. There are several objections an expert witness is likely to encounter. One is relevance. A question may be challenged if it does not relate sufficiently to an issue in the case. Another is hearsay, which generally involves an out-of-court statement being offered to prove the truth of what the statement says, although there are numerous exceptions and special rules that may apply. An attorney may also object because a question is argumentative, meaning the attorney is essentially arguing with the witness rather than asking a legitimate question. A question may be objected to as asked and answered when the attorney repeatedly asks essentially the same question after the witness has already responded. There can also be objections when a question assumes facts that have not been established, mischaracterized previous testimony, calls for speculation, or goes beyond the expert's area of expertise. Another important objection involves compound questions, which brings us to the next issue. From the expert perspective, there is one very important rule. When you hear an objection, stop talking. Don't try to decide whether the objection is correct. Don't answer around it. Wait for the judge. The judge will either sustain or overrule the objection, and then the expert can proceed accordingly. A compound question contains more than one question within it. For example, you examined the evidence, followed by the laboratory procedure, and determined that the samples came from the same source, correct? There is actually several separate issues in that one question. Maybe I examined the evidence, followed the procedure, but I cannot scientifically say the samples came from the same source. Simply answering yes could unintentionally agree with something I do not actually believe. A better response might be, there are several questions there. Could you ask them separately? Or I could explain which portion I agree with and which portion I do not. A leading question, on the other hand, suggests the answer the attorney wants. For example, there is always a possibility of laboratory error, isn't there? Leading questions are particularly common during cross-examination. The expert should listen carefully before automatically agreeing. If the scientifically accurate answer is yes, then say yes. But if the answer requires explanation, provide the necessary qualification rather than allowing the attorney's wording to define the expert's opinion. The important thing is to not fight the question. Listen, think, then answer the question that was actually asked. There are several ways a forensic expert can make direct examination more effective. First, speak to the jury, not just the attorney. The attorney may be asking the questions, but the jury is the audience that needs to understand the answers. Second, avoid unnecessary technical language. Scientific terminology may be necessary, but when it is used, explain it. For example, instead of simply giving a technical term and moving on, an expert can say, what that means in simpler terms is. That small explanation can make a major difference. Visual aids can also be extremely useful when they actually clarify the testimony. Photographs, diagrams, charts, or demonstrations can help jurors understand information that would otherwise be difficult to visualize. However, a visual aid should support the testimony rather than distract from it. Another important element is demeanor. The expert should be professional and confident without appearing arrogant. There is also a difference between confidence and certainty. A confident expert can still acknowledge limitations. In fact, acknowledging legitimate limitations can make an expert more credible because it demonstrates that the expert understands where the science stops. Understanding the goals of cross-examination. Understanding what opposing counsel is trying to accomplish during cross-examination can make the process less intimidating. The attorney may attempt to limit the impact of the expert's testimony. They may challenge the expert's qualifications, methods, assumptions, conclusions, or interpretation of the evidence. They may identify inconsistencies between testimony and the expert's report or previous statements. They may also emphasize limitations. For example, an attorney might ask, "You cannot say with absolute certainty that this sample came from my client, correct?" That question may be completely legitimate depending on the science involved. The problem occurs when an expert becomes defensive and starts trying to protect the conclusion. That is not the expert's job. If the scientifically correct answer is correct, testing cannot establish that with absolute certainty. Then that is the answer. Opposing counsel may also attempt to obtain favorable information from the expert. That is another reason the expert should never think of themselves as belonging to one side. The expert's testimony should remain the same regardless of which attorney is asking the question. One of the best ways to reduce vulnerability during cross-examination is to simply know your material. Not memorize it, know it. Understand what you did, why you did it, what the results mean, and what they do not mean. The expert should also listen to the entire question before answering. Silence can feel uncomfortable on the witness stand, but there is nothing wrong with taking a second to think. Another important rule is don't volunteer information. Answer the question that was asked. If the answer is yes, say yes. If the answer is no, say no. If the answer cannot accurately be reduced to a yes or a no, explain that. An expert should also avoid arguing with the attorney. Cross-examination can sometimes feel personal, especially if the attorney challenges the expert's competence or credibility. Becoming visibly angry, sarcastic, or defensive can damage the attorney's credibility much more than the original question. Instead, remain calm and professional. If you don't know something, say, I don't know. If you don't remember, say, I don't recall. And if the attorney misstates your testimony, that's not what I said. Those are perfectly acceptable answers. Experts can also reduce their vulnerability by acknowledging limitations before opposing counsel makes those limitations look like something the expert was trying to hide. A limitation does not automatically make scientific evidence unreliable. Sometimes it simply defines how far the conclusion can reasonably go. Ultimately, effective expert testimony comes down to preparation, communication, objectivity, and professionalism. The expert needs to understand the phases of testimony, know the scientific work behind their conclusions, recognize potentially problematic questions, and understand what opposing counsel is trying to accomplish. But I think one of the most important things to remember is that an expert witness is not there to win the case. An expert is there to explain the evidence. Whether the answer helps the prosecution or the defense should not change the answer. If an expert understands their material, recognizes its limitations, communicates clearly, and remains composed under questioning, they are much less vulnerable on cross-examination and much more useful to the court. That credibility is ultimately what makes expert testimony effective.